So for Jonathan, and to follow up on John McGinnis's question, I suppose I fail to see the advantage of the approach because the way I see it, take for example the Massachusetts decision in the marriage cases. Mm-hmm. Suppose for whatever reason the Supreme Court takes it up, reverses it on state law grounds. Mm-hmm. It seems to me that what would result from it is that when the case came up in California and thereafter in Iowa and Connecticut, the state courts would get the message that whether it's at on federal or state grounds, Supreme Court is going to take him up and reverse it. You know, if they decided the wrong way, or just like Massachusetts did. So whether you denominate it as a federal constitutional issue or simply a reversal of a state misinterpretation of its own laws, ultimately you end up with a uniform federal decision that states courts, while not required to follow, will do so because they'll know, should they not, they'll get reversed. So I don't really see the advantage of simply saying, oh, we're going to avoid the constitutional issue, we're going to decide on state law grounds. Ultimately, the result is exactly the same.
I don't propose having the Supreme Court reverse the Massachusetts homosexual marriage decision. They didn't grant certiorari in that case, and my proposal is limited to situations in which they are going to reverse the state Supreme Court. And the only question is whether they're going to do it on federal constitutional grounds or whether there's a state law basis to justify the reversal that's easier for the court to defend. Now, as a matter of the Supreme Court's legal prerogative, if somehow the state of Massachusetts could concoct a federal constitutional claim and appeal that state Supreme Court ruling to the Supreme Court, they would have the jurisdiction to do it. But they didn't exercise that power in 2003, and I don't argue that they should have exercised that power, even under my limited proposal. So I'm arguing that they have the power to do this, and the question is when they should do it. And my argument is that they should only do it when they're going to avoid a reversal that would otherwise rest on some novel, highly contentious federal constitutional pronouncement that they're likely to get wrong.
Yeah, this is also for Jonathan, and it's actually kind of a. I actually will confess I had the same idea a couple years ago that this should happen. And I think that one question is, empirically, how much bad constitutional law comes out of these decisions. And I think that you may address this in your paper, yeah. but I think that the case for doing it is basically that, to some extent, the Supreme Court, even though it's supposed to function in this sort of way of just straightening out federal law, actually is affected by results and by demands, by a desire to intervene in cases not for reasons that have to do with the legal strength of the federal claim, but rather because of the result, right?
Right.
That's sort of a key element, and there certainly is a case for that in terms of just the fact that when the Supreme Court grants certiorari, I mean, I don't remember exactly what this number is, but something like 2/3 of the cases it reverses. So it doesn't just randomly grant certiorari in cases that it thinks are important and that satisfy the rules for granting certiorari and the standards for granting certiorari. Somehow the results play into when it grants certiorari, and there seems to be this category of cases in particular where it really wants to straighten out a result, and so you may already be bringing this out in your paper, but this is more of a suggestion, I guess, than a question. That seems central to your argument to me.
Yeah, I try to avoid taking a position on what counts as bad constitutional law. The examples I select are cases in which the federal constitutional pronouncement is highly controversial, and I think everyone would find at least one of those examples to be mistaken, depending on where you fall on the political spectrum. So the claim in the paper is that there will be some error costs associated with these federal constitutional rulings. Which cases count as errors isn't something I try to resolve in the paper. And if the Supreme Court is going to issue the reversals, if they do it on state law grounds, at least that's a way to minimize the damage that they're doing. Because at least in those situations, they won't be entrenching a federal constitutional pronouncement that can't be changed.
I wanted to pick up on Naomi's question in her dwarf throwing. what would be the constraint in the dignity question of how would one respond to saying, well, you can't, well, we're going to ban Jerry Springer, families going on Jerry Springer.
What would be the
And families going on Jerry Springer, where they somebody comes out and explains that, and yells about somebody else having cheated on them or whatever, and reality TV. The effect on human dignity surely is comparable with some of the other issues. So how does one structurally, how is it suggested that one structurally goes about drawing lines there?
Well, I guess my let's look closer. My interest was to sort of separate out that kind of dignity, where people are making a judgment about what's dignified, right? I mean, obviously there are thousands, maybe millions of Americans who think it's a great idea to go on Jerry Springer, right? So then the question is, can there be some sort of state policy or federal policy that's grounded on these sorts of dignity judgments? And obviously people will disagree about that, right? But then, but what that kind of dignity argument is clearly not is the dignity of autonomy, right? Because if you're just concerned about basic dignity, the dignity of choosing how to live your own life, then surely we should allow people to, make a fool of themselves or embarrass themselves in whatever way they choose. So I guess I'm not taking a stand necessarily, although I tend to be opposed to these sorts of social regulations, but they're grounded on very different ideas about dignity, which is really my point. Does that answer the question?
You're not making a normative judgment.
Right. And I think, to Professor Epstein's point, I do tend to prefer dignity 1, as it were. But
Naomi, I don't know if it's a question or a suggestion on this particular paper, but one of the things that struck me since I've worked in the areas of dignity is you don't have a single word about the use of dignity in connection with medical ethics, which is actually a very interesting product. If you want to watch the transformation of Dignity 1 into Dignity 2, try your eye on the Belmont report, which was sort of the basis of having institutional review boards so as to make sure that no patient can get the medical care that he or she wants. And what it does is it starts off with a theory of dignity, which is tied to autonomy, and then it assumes that medical decisions are hard, so therefore competence is an issue, and so therefore protection becomes the norm. And I do think, in effect, that what you really do have is a nice illustration, because one of the themes that's not sufficiently stressed in your paper when you talk about dignity is the paternalist overtones that come, either pro or con. So Lochner, in many people's minds, is not an opinion about the matchless efficiency of the market. It has some of those elements, but it's an anti-paternalist decision, right? And when you start looking at the modern stuff, they become very pro-paternalistic. And you take that, try Abigail Alliance on for size. Are you familiar with Abigail Alliance? Let me just mention, this is a case on the question as to whether or not when drugs go through phase 1 trials, and just assume for the sake of argument that a phase 1 trial is we give very high doses to very few people, and if they still are standing at the end of the day, you go on to see whether or not the drug is effective. And there are a lot of people who are sick in the cancer community and so forth say, hell, I don't even care about phase 1 trial, but basically their position in this case is, if this thing doesn't kill you, it's for me to decide whether it's going to help me. And they bring these claims. And the Supreme Court basically follows a case called Rutherford, which says the power that the United States government has over the health and safety means that if you're foolish enough to want to use a drug which hasn't gone through all of these trials, we're not going to let you do it. And of course what's galling is the only people who don't know how to do expected value calculation is sitting in the FDA for the individual cases. But that's a classic illustration in which this goes on. And I have to tell you, the response of the sick people communities there, they go berserko over this. And Abigail Alliance was formed when Father Burroughs was trying to get Erbitux for his daughter who was dying of cancer. And after going through all the red tape at Pfizer and at the FDA, it arrived on the day she died, before it had been approved. And, frankly, I would be a little upset about that as well. So, I mean, I do think that that's a very rich area, and maybe a separate paper, because this is, Lord knows, long enough.
It's very complicated, the whole dignity,
but
bioethics.
But I mean, and there's a whole book that they put out in the NEH, or whatever it is.
The Leon Cass book.
I mean, oh my God, and these people, they snipe at each other with a level of vitriol which, you know, is matched by the insignificance of their contribution in many cases. But it really does have that sort of feel. And you got to go at some point to the medical ethics. And the other thing is Blaustein on privacy.
Right.
It was an early
article.
And turned out to be a loser, I think, in terms of the way in which the field evolved.
So unless, Naomi, you want to take a 1-minute response to any of that? I think you were nodding along. So.
Yeah.
So I want to thank and congratulate our speakers this evening for terrific contributions, and especially our esteemed commentator as well. So thank you.